documents that you need to complete. In fact, you don't even have to have a written agreement between the partners regarding what the rights and duties are of the partners, how they will vote on making decisions for the partnership. You don't, how much money one is giving, how much expertise the other partner is giving, how they're going to split the profits. You don't have to have anything in writing. It can be by the shake of a hand. This is what we agreed to. Okay, now let's go and do it. So there are no formal requirements. There are also possible tax advantages because that partnership, if it is in 2 personal or 20 private individuals, your personal tax that you're going to pay on the profits that this partnership has made is much less than the tax bracket of a company or a closed corporation or a trust. Your personal tax is much less percentage-wise that you pay on your income as opposed to a company. You can also set off, the partners can set off the losses of the partnership against the profits that were made. There are few administrative requirements. For example, the company and closed corporation must have an appointed auditor. They must have annual audited financial statements. Whereas a partnership, you don't need any of those things. So there's no red tape. And the assets as they appear on the partnership balance sheet, those are the assets of the partnership. And the assets of the partnership are owned jointly by the partners themselves. Unless one partner said, look, we're going to open a little office for this partnership. I don't need a TV in my spare bedroom at home. I'm going to bring this TV and put it there in the reception area so that we can show adverts or pictures or what we do and brochures, etc. So then, unless the partner only gave an asset for the partnership to make use of, normally then all the assets in the partnership are owned by all the partners equally and jointly. A company, closed corporation, and natural people like you and me may be partners in a partnership. So a company can also form part of a partnership. A closed corporation can also form part of a partnership. So it's not impossible, they can. Then the disadvantages, as I said, there's no limited liability for the normal partners in a partnership. If my brother and myself enter into a partnership to build and install kitchen cupboards, and for whatever reason the partnership cannot pay the debts, then we are personally liable for those debts. So it will affect my personal estate. My personal house might have to be sold in order to satisfy the judgment creditors against the partnership. So there's no limited liability like in the case of a closed corporation or a trust or a company, where the directors or the members or the trustees will never be personally liable for the debts of the company or the trust unless they sign surety. But normally, if they didn't sign surety, it's 2 separate entities altogether. I will never be personally held liable if I'm a trustee in a trust and the trust goes insolvent. It doesn't affect me personally. It doesn't affect Heindesel whatsoever. They can't come and touch my money that I've got in my personal bank account or my house that's in my personal name. Never. And that's the issue with partnerships. There's no such limited liability. You as the partner will be liable for the debts of the partnership. There's no perpetual succession as we discussed. So if one partner resigns or a partner dies, or even if a new partner joins the partnership comes to an end, it's dissolved, and a new partnership will have to be formed, as opposed to companies and trusts and whatever. That trust and that company will carry on till doomsday. Doesn't matter how many of the directors resign, how many directors join the company or trustees, etc. It will continue regardless. And then there's obviously risk or unauthorized contracts. So make sure that you enter into such a partnership, I suppose, with somebody that you trust. So, if, let's say, for example, my brother and myself enter into a partnership, I trust that he'll do the right thing. I'll trust that he will spend the money of the partnership to purchase flyers like he promised, to purchase maybe timber from Timber City so that I can build the cupboards and install them. I don't want him to buy a jet ski on behalf of the partnership that he uses at his holiday home in Hermanus, because that doesn't form part of the partnership. That wasn't what we agreed to. So the difficulty or the risks involved with a partnership is that you must trust your partners, because it was with a shake of a hand that we agreed this is what we're going to do. So go and do it. Now, if you go and buy a jet ski or a boat or whatever for the partnership, it's not for the benefit of the partnership. You're just using it on your own. So then there might be arguments, etc., that might arise out of that. Unauthorized contracts being entered into, where the other partner did not agree thereto. That was the original agreement that the parties set out to be the goal of the partnership. Then partnerships continued with regards to the management of a partnership. All partners in ordinary partnership may take part in the management of the partnership unless the partners originally agreed that, listen here, we're going to form this partnership. We are 5 partners, A, B, C, D, and E. Only A, B, and C will manage the partnership on a daily basis. The other 2 partners are actually just silent partners. They cannot be involved with the day-to-day management of the partnership. But that will have to be in the agreement then. But normally, as a general rule, all the partners are involved with the management of the partnership unless they've agreed otherwise. Ownership of the partnership property, the assets are generally owned jointly by all the parties, unless one of the partners only lent an asset to the partnership. Then that asset that the partner lent to the partnership doesn't form part of the assets of the partnership. The decision making in the partnership, partners can make decisions formally or informally. No need for a formal resolution. So in a partnership, you don't have to have resolutions, etc. It can, as I said, it can be by the shake of a hand making decisions. You don't need a resolution to make decisions. As a partnership is not a juristic person, such as a company, a trust, or a closed corporation. Company or trust, closed corporation can be a partner in the partnership, but the partnership itself is not a juristic person. So what would happen now, considering all of these things? So you don't need any formal written agreements between the partners. You don't need any resolutions when you make decisions on behalf of the partnership. It can be by the shake of a hand. You must just hope and pray that you trust your other partners, that they will act responsibly and enter into contracts that you would be happy with if you had any say in it, etc., etc., etc. But what would happen now if the partnership goes to a bank and say, right, Mr. Bank Manager, we as the partnership, we want to take out a mortgage bond over a property. We don't have a formal agreement. We don't have anything like that. The bank will say, well, sorry, guys, we as the bank, we want to safeguard ourselves. We're going to require you to enter into a written agreement so that we can see who the partners of this partnership are. Who are the partners? So write some other agreement. It can be obviously after the fact. The partnership might have been created 10 years ago. Now, after 10 years, the partnership go to the bank and say, hey, we want to borrow some money. The bank will say, no. First enter into an agreement. Put your agreement in writing so that we can see who the partners are, who's going to contribute what. How are you guys going to split the profits and the expenses of the partnership, etc., etc., etc. So the bank, when you go to the bank will require the written agreement. to show who the partners are. And the bank will also want to have a look to see that this person who is now taking out the bond on behalf of this partnership, is he duly authorized to take out the bond, to bring this application on behalf of the partnership? So there must be something written in the partnership that the partnership can take out, purchase properties and take out mortgage bonds, etc., etc. And that there must then be a resolution by the partners, a unanimous resolution authorizing one of these partners to go and sign documents. So the bank will require that. Even though if our partnership never purchased a property or took out a bond, it will not be legally required for us to have that as a partner, as the partners in the partnership. But because the bank is involved, the bank is going to say, no, guys, we want something formal. We want to safeguard ourselves, have a written agreement showing who the partners are, and how you're going to manage this partnership. Give us a resolution signed by all the partners, confirming that your partnership has now decided to purchase a property and take out a mortgage bond, and that Piet Pompies is authorized on behalf of this partnership to go and sign all the documents on behalf of the partnership. Then the bank will be happy. And again, obviously, the bank will still require the usual FICA documents. They'll require proof of address of all the partners, the ID documents, the income tax numbers, maybe bank statements of their income and expenses. The bank will also want to know what the marital status of those partners are. So those are the requirements that the bank will have. Even though it's not legally required for the partnership to have those things, the bank will definitely say, guys, we need this to safeguard ourselves, to make sure that everything was done above board, so that we don't have a partner that turns around in a year's time to say that he never authorized this bond, and they had a verbal agreement that all of them must decide to take out a mortgage bond. No. Put it in writing, get the resolution signed, give us the FICA, your income and expense, your personal income and expenses, because essentially it's a partnership, but it's still you personally that's liable for that. So the bank will require that from a partnership. Trusts. So let's skip ahead to trusts. Trusts are often party to obviously a loan agreement, because trusts buy and sell properties on a daily basis, and mortgage bonds get registered in the name of trusts, and trusts enter into loan agreements with the bank, where they agree to repay the bond, etc. The same as a normal natural person. They also act obviously as a trust, as a juristic person, and the people within the trust will make their decisions and sign all the necessary documents. There are certain essential requirements when dealing with trusts that are often overlooked, and that's the important things that we're going to have a look at now quickly. So just to give you an example, a very good example of a very clever lady, Mrs. Smith. So what happened was, Smith versus Absa Bank, a judgment was handed down in the Gauteng High Court. What happened was, Mr. Smith, Mrs. Smith, and a Miss Keat created a trust called the Nelmary Trust. So they were 3 trustees. At some other point in time, Miss Keat, probably an independent trustee, maybe the accountant or maybe the attorney or whoever, resigned as trustee, and there were only 2 trustees. The trust deed that sets out the rights and the duties and what the trust can do and not do and how they must vote. The trust deed said that there should be 3 trustees at all times. However, if there are only 2 trustees, then the trust can make a decision to do something with a unanimous resolution signed by the trustees. So in this scenario, there were only 2 trustees, Mr. and Mrs. Smith, and they can go and take out mortgage bonds, do whatever they want to do, as long as there's a unanimous resolution. So both of them agreed to do a certain thing. So in this scenario, what happened was, Ms. Keat resigned as trustee, so there were 2 trustees, Mr. and Mrs. Smith. Mr. Smith went then and he took out a loan with Absa Bank. He signed the mortgage loan agreement and all those lovely things. and Mrs. Smith stood surety for the trust. So she signed the suretyship for the trust. What happened? The trust didn't pay the monthly bond installment. Absa Bank took action against the trust and then obviously took action against Mrs. Smith as well, because Mrs. Smith signed the suretyship. So the bank can go after her personally as well. So what happened was Mrs. Smith said, but hang on, that loan agreement was entered into by Mr. Smith, my husband. He signed the loan agreement and the bond documents and all those lovely things. But according to the trust deed, the trust deed requires a unanimous resolution by at least 2 trustees before a mortgage bond can be taken out. So in this scenario, Absa Bank, did you get a resolution by me and my husband to take out the mortgage bond? No, it was just Mr. Smith that signed it. Well, the trust deed doesn't allow for that. It specifically requires a unanimous resolution by at least 2 trustees. I, Mrs. Smith, never signed the resolution. I never co-signed the loan agreement with my husband. So this suretyship that I signed on behalf of the trust was signed based on an unlawful, invalid loan agreement that my husband signed. So Absa Bank, because you didn't get the resolution by both of us authorizing him to go and sign the documents, that agreement is invalid because the trust deed doesn't allow us, me or him, to enter into an agreement with the other person's consent or resolution. So because that loan agreement that my husband signed on his own without my authority is invalid, the suretyship that I, Mrs. Smith, signed is also invalid. It's got no force and effect. So the Absa Bank cannot come after me because it's an invalid suretyship. And the court agreed with it. The court said, you're absolutely right. They can't enforce a suretyship that you signed. The suretyship was signed based on a loan agreement that the trust took out. But that loan agreement that the trust took out is invalid. The trust deed doesn't allow just Mr. Smith to enter into the loan agreement. So the point is, it's very important for the banks, for estate agents, for attorneys to get a copy of that trust deed, because that trust deed will say exactly what those trustees can and cannot do. Further, it will tell us how they can do it. Must it be by a unanimous resolution? Must it be by a simple majority resolution? If there are 3 trustees, then only 2 need to vote. But it might say it must be a unanimous resolution. So if you guys want to buy and sell property and take out mortgage bond, and there are 4 trustees, it must be by way of, for example, a unanimous resolution. Then all 4 trustees must sign the resolution to confirm they've agreed now to sell a property or buy a property or take out a bond. So the trust deed is very important to have a look what the rights of the trustees are. What can they do? The trust deed might say the trust may not sell any property, for argument's sake, or may not take up mortgage bonds over properties. Then if you've got a purchasing trust to say, hey, we want to buy a property and we take out a mortgage bond, well, hang on, let's have a look at the trust deed. Mr. Trustee, the trust deed says you are not allowed to take out mortgage bonds. So you can't. It's impossible. So it's very important to look at the trust deed. What authority do they have as trustees? What can they do? And secondly then, if they've got that authority to take out a bond, well, what type of a vote must be there? How many of the trustees must agree thereto? Unanimous, a special resolution, whatever. So that's very important to have a look at the trust deed to determine what they can and can't do. So there are important considerations for the trust. Make sure, as I said, the transaction is authorized by the provisions of the trust deed. Can they buy and sell property? Can they take out mortgage bonds? Does the trust deed allow them to do this? What are the decision-making requirements? What does the trust deed say? How many trustees must vote on these decisions? And what type of a majority vote must there be for them to proceed then with that decision? And when can somebody act as a trustee? So normally, not normally, when you create a trust, you will lodge that trust deed at the master's office. Every trustee that would want to be, and in the trust deed, it will tell us who are the initial trustees of the trust, and those trustees will provide their ID documents. They will provide their acceptance. I accept to be nominated as a trustee, and I'll accept my position as a trustee of this trust, and I promise to abide by the Trust Control Act and to do everything to the benefit of the trust. This is my residence, this is my postal address, this is my cell phone number and email address, etc., etc., etc. The master's office will then issue the letters of authority to say, right, this trust has now been registered. This is the trust number, IT2697 of 2021. And these are the trustees of the trust that have been duly appointed as trustees. So on the letters of authority that the master's office issues, over there you'll see who the trustees are that can act on behalf of that trust. And a trustee can only act if he is on a letter of authority. Sometimes you will find that, for example, let's say Mr. Smith, Mrs. Smith, and Ms. Keat. Let's use that example. So on the original letters of authority that the master issued, those three names would appear on the letters of authority. If Ms. Keat has now resigned, she doesn't form part of that trust anymore. So strictly speaking, when the attorneys or whoever signed the trust documents require the letters of authority, they'll say, but Ms. Keat is there. Where's Ms. Keat? She must sign. Mr. and Mrs. Smith will say, well, no, she resigned. Well, where's the letter of her resignation? That will now influence the letters of authority. No, but our neighbor, he's an attorney, and he'd agreed to now become a trustee of the trust. Well, he must now be appointed. He can't sign the resolution on behalf of the trust if he has not formally been appointed as a trustee by the master of the High Court. So because you apply to the master office maybe to be appointed as the trustee, and you've signed your acceptance as the appointment as the new trustee, that's fantastic. But you've got no authority to act until such time as the master's office issued the new letters of authority showing that Mr. Smith, Mrs. Smith, and Piet Pompies, they are now the trustees to act on behalf of the trust. So it's important that only the trustees that appear on the letters of authority, only they can act or make decisions on behalf of the trust. No one else. So with regards to trusts, obviously, for trusts, it's very important to ensure that they keep proper bookkeeping of minutes of meetings, of resolutions that they've taken, decisions that they've made. That has to be on file. The trustees are replaced in case of resignation or disqualification. So trustees can be replaced. The trust will still continue. It's not like a partnership that will come to end if one resigns or is disqualified or die, whatever. It will still continue. The provisions of the trust deed are heeded at all times. Make sure that the provisions of the trust deed are complied with and that the trustees do what they are allowed to do in terms of the trust deed, and that attention is paid to compliance with the trust deed's specific requirements regarding the passing of resolutions. How many trustees must vote? Must it be unanimous? Must it just be an ordinary resolution? Must it be a special resolution with 75% maybe agreeing to do something in respect of the trust, etc. But the trust deed is so important. It will specify exactly what needs to be done, what the trust can do, and if they want to do that, who must authorize it, and by what type of a resolution, voting, special resolution, unanimous resolution, all the trustees must agree thereto, etc., etc., etc. Because like we saw in that case law, if one of those things are not done, one of the trustees can come back to say, guys, I never authorized this in terms of the trust deed. It had to be a unanimous resolution. I never agreed yet to, so that offer to purchase, or it's invalid. You can cancel it. You can throw it in the bin. It's not worth the paper it's written on. So that is why the trust deed is very important, to comply with all those requirements and formalities in order to get the trust to do anything properly and legally with the necessary authority. Then with companies, each own its assets, obviously, in terms of the company, the assets are earned in the name of the company, and the company will be liable for the debts of the company. Offers limited liability to the owners and the shareholders. The shareholders and the owners or the directors of the company has got limited liability because the company is a separate entity from their personal lives, unless they sign suretyships. But normally the company is a separate entity. So if the company is declared bankrupt or is declared insolvent, then it doesn't affect the directors of the company or the shareholders of the company. They cannot be held personally liable for the debts of the company. Obviously, with regards to companies, there are more formalities as opposed to a partnership. There are a lot of formalities, so there's a lot of documents that will have to be drafted and signed by the directors and shareholders. There will be a memorandum of incorporation that will set out the rights and duties, responsibilities, and obligations of the directors and the shareholders. There'll also be a notice of incorporation that will be sent to the registrar of companies to advise the registrar of companies that these people, these parties are going to be directors and shareholders, and they want to create a company, and this will be the objective of the company. It will be a property selling company, or whatever the goal is of the company. It will set it up what the purpose of the objective of the company would be. So there are more documents and requirements and formalities that will have to be met, and you can only act through its organs, namely the board of directors or the body of shareholders. They make the decisions on behalf of the company. And specifically, with regards to the sale of property, when a company sells a property, there are certain decision makings that has to be complied with, and we'll look at it. There are specific scenarios as well. Okay, so decision making process for a loan. The board of directors of the company will meet on a regular basis to discuss the day-to-day managing and running of the business. The decisions will then be reduced into, they'll have minutes of meetings, and once they've made a decision to do a specific thing, they will then pass a resolution to say, right, we've now decided we want to do X, we want to take out a bond. Right, let's sign the resolution. We confirm, we've all agreed, all our directors, we've agreed that we want to take out a bond over this property, and that we're going to appoint Piet Pompies as director to go and sign all the documents on our behalf. So the resolutions are taken by means of a voting, whether they agree or whether they don't agree with the proposal. Normally, each director will have one vote, and normally it just will be a simple majority. 51% will normally suffice, unless in their articles of association, etc., they agreed originally that if it comes to property or immovable property transactions, the selling, buying of property, taking out a mortgage bond, then we want a special resolution. Then at least 75% of us must then agree to sell or buy property or take out mortgage bonds. So it all depends on what the articles of association and all those things say, what was originally agreed to. But again, those requirements must be followed. And if it wasn't done as per what originally was agreed to, that contract or agreement or bond is invalid. Even a unanimous resolution may even be required if that was what was agreed to originally. Originally they might have agreed that in the event that we take out a mortgage bond at any time in the future, then there has to be a unanimous resolution by all the directors that we take out a mortgage bond, failing which they won't be able to take out a mortgage bond. Now, the shareholders may generally not interfere with this day-to-day running of the business. Generally, however, there's one instance with regards to conveyancing where there's a special resolution required when a company sells a property. If that property that they are selling is their main or only asset. So in terms of Section 112 of the Companies Act, it says that where a company sells the whole or the greater part of the business or the assets of the company, or the whole or greater part of the assets of the company, a special resolution of the shareholders of the company is required. Not only the directors, even the shareholders of the company must, by way of a special resolution, which means 75% and more of the shareholders must agree thereto, must agree that the company sell or dispose of the asset. For example, if a company owns just one property, just to make it easy, and it decides to sell the property, then obviously they are disposing of the only or the major greater part of the assets. They only own that asset and they're now selling it. Then compliance with Section 112 is required. Therefore, a special resolution passed by 75% of the shareholders must be passed. Section 112, now what is the reason for this? Section 112 aims to prevent directors from disposing of the whole or substantially the whole or greater part of the company without the approval of the shareholders at a general meeting. The resolution must be filed at the Registrar of Companies offices, and many formalities and legal requirements that companies must adhere to in property transactions must be adhered to. So if we just have a look, the documents for a company that the banks will require or want to have a look at. The banks, with companies, there's a hell of, and your mortgage originator will tell you, obviously, that it's such a schlep when a company applies for a mortgage bond because there are a lot of documents that are required. So if we just have a look over here, the memorandum of incorporation that we've discussed earlier, setting out the rights and duties and obligations and what the mission statement and what the whole idea or the purpose of the company is, that must be filed. The notice of incorporation, the notice that was lodged at the Registrar of Companies that the company is being incorporated. There must be a statement by the auditor that the company is solvent and that there are no action to liquidate the company. Must also be lodged with the bank. The registration certificate that would have been issued by the Registrar of Companies to show the company is now duly registered and the company can commence business to act as such. That must be lodged with the bank or the mortgage originator. A resolution authorizing the transaction and authorizing a specific director to sign the document. So yes, obviously there must be a resolution by the directors authorizing a specific director to just go and sign all the documents on their behalf for them, so that the 20 directors don't have to sit there and sign each and every single document. It's too much of a schlep. Rather just, we've decided we're taking out a bond and we appoint Piet Pompies to be the lucky one to go and sign all the documents on our behalf. If the transaction involves an alienation of substantially the whole of the asset of the company, then there must also be a resolution by the shareholders, a special resolution. So 75% of the shareholders must agree thereto. Then notice of registered office. So the bank will also require, it's a form Oct2021, which is a form that the Registrar of Company issues, which is confirmation as to what the registered address of the company is, as well as the postal address. The bank will obviously also require the normal FICA documents, the normal copies of IDs, proof of residence, marital status, all those things. And a further requirement in terms of the Financial Intelligence Center Act is obviously they must have a look to see, are there any beneficial owners that does not appear as a director or a shareholder, a very silent partner that benefits from any funds that give funds to the company or that might benefit from the profits of the company that you would not find as a director or as a shareholder, because it's a beneficial owner and FICA has changed. We need to now determine, are there any beneficial owners that gets a benefit from this company. The COR 39, the contents of the register of directors, auditors, and officers. So it's also just a form issued by the Registrar of Companies, showing the company name, listing all the directors, listing the main place of business and postal address as well, and the financial auditors of the company as well, and the necessary FICA documents relating to the company and the directors. So again, the directors, they will all be FICA'd, IDs, marital status, income tax numbers, bank statements, and all those lovely things. So if we have a look now at the partnerships are very informal. You don't even have to have a written agreement. It can be by way of a handshake. The only stuff up is that you need to trust your partner. You must make sure, you must hope and pray that he doesn't go and buy or do something on behalf of the partnership that you didn't originally agree to. The partners are personally liable for the debts of that partnership, not like a company or a trust or a closed corporation where you as a director can hide behind and say, no, you can't come after me personally. It's the company's debt or the trust's debt. So those are things that you must consider when you want to decide, when you want to take out, create a partnership, etc., etc. And with regards to trust, the most important thing is get a copy of the trust deed. Have a look whether this trust can buy or sell property, whether they can take out mortgage bonds. And secondly, who is going to be authorized to do that? And how do they need to authorize or vote to get that done? Because if the voting wasn't done, like in the Smith versus Absa Bank case, they can turn around to say the agreement is not valid. Thank you very much. And with regards to the company, obviously, the directors will make all the decisions. The shareholders don't make a decision unless a greater part of the assets of the company is sold. Then the shareholders must, especially by way of a special resolution, must also agree to the sale of the property. So those are the formalities, and then obviously those are the things that the bank will require. The bank will require the partnership to have an agreement, to have a resolution, for the trust to have a copy of the trust deed, to have the resolution, to make sure that the trustees voted properly as per the trust deed. And for a company, again, the company documents must be there. The memorandum of incorporation, the articles of association, the registered address of the company, etc., etc. So those are the formalities that the banks require and that the law require when companies, trusts, those corporations enter into agreements, that we just make sure that we follow the right rules and regulations. And that is it, guys. And I'm already at the thank you part. And I just want to have a look here. I see a hell of a lot of good mornings. So again, good morning all. But obviously,